Good morning, gentlemen. Can you hear me?
Yes, Judge. Good morning.
Good morning. Mr. Hernandez, did you unmute?
Good morning, Judge. Sorry about that.
All right, good morning. We're here on the September 21st, 2020 docket. And I believe we're here on Jessica Gomez versus Luis Gonzalez, CL 20-0767D. And gentlemen, I see we have here like 3 or 4 motions. 1, 2, 3. Yeah, it's about 3 or 4 motions, right, sir? 4?
Yes, Your Honor.
All right. All right, who wants to get it started?
I can go first.
Okay. All right.
I have, real quickly, I have a motion to compel the corporate representative and Luis Gonzalez. And basically, Judge, this is a civil lawsuit involving negligence from the standpoint of there was a Ms. Gomez and her daughter who lived in an apartment and was bit by ticks or an infestation of ticks. And so we have sued Luis Gonzalez, who is the owner of a fourplex, the next door neighbor fourplex, who we are alleging, short story is that they knew about ticks, the infestation, they never did anything about it. And those from the dogs that were living in the adjoining, well, it's not adjoining, but if you could imagine 2 fourplexes and then a fence that separates the 2 fourplexes. And then Ms. Gomez lived in one apartment and her backyard fence abutted to another fourplex, which was Mr. Gonzalez's fourplex. And those dogs had ticks and they were coming over and that was the infestation issue. Trying to get and do the fact, obviously, discovery. We tried to get these done back in April of 2020. And so we really need relief with regards to doing that discovery to depose the corporate rep of the apartments and Luis Gonzalez, the owner. And that's what we're asking for.
And Your Honor, if I may,
Yes, sir.
we don't have any objection to presenting Mr. Gonzalez for deposition. We do have an issue, just to give you a brief history about how the subpoenas and the procedure was done to begin with. This lawsuit was filed in February, and my client was not served until April 13th. 7 days after he was served with the petition, he was served with subpoenas for his deposition to take place 17 days after he was served with a subpoena. So really, the subpoena called for his deposition just a couple days after his answer deadline. And Your Honor, that's why we were forced to file a motion to quash and a motion for protective order, because the subpoena also had document production requests, and the document production requests were obviously scheduled for the same time as the deposition, which only, even if were issued and served properly, which we allege they were not, would have only given him 17 days to respond, which again doesn't even give him the 50 days, which would have, he would have been allowed as the discovery was sent pre-answer deadline. So Your Honor, we do not have a problem with presenting the defendant at a reasonable time. I'm not sure if Mr. Hernandez was thinking of doing this by Zoom or in person. I guess we can talk about that after the hearing. As far as the corporate representative goes, I guess we need to talk about that also, since he was sued individually. He's the owner, so I guess we can talk about who Mr. Hernandez is thinking the corporate representative is. But as long as that they are scheduled at a reasonable time and place, probably by Zoom right now because of the virus, then we don't have any problem with that, Your Honor.
Okay.
Judge, if I just may, just to respond to that, it's been since February to September, and there's been no movement. They had plenty of time, and so I hear what he's saying, and I appreciate that. I would appreciate if we could do in person, if that's okay. If the court says Zoom, that's fine. I will adhere to whatever the court's recommendation is on that. And the way that typically the lawsuits are filed that I have is that I'll have a deposition notice that goes along with serving. And so that's what he's talking about. Yes,
Sure.
it is. Yes, it is aggressive. It is an aggressive procedure. It's not unlawful, but I'm just trying to move the case because obviously the situation regarding the minor and the tick infestation, all that, I'm trying to get that moving. So,
All right, we'll do it through Zoom.
okay.
Okay, so just work out the details. It'll be a Zoom.
Yes, Your Honor.
Okay, which is
And
the
then,
next.
Can we get an agreement that the depots will be done within 14 days since it's been already 6-7 months already?
Your Honor, we would ask for at least 30 days on a deposition. I mean, we're going to have to schedule, look at our schedules and go back and forth.
All right, we'll make it 30 days.
Thank you, Your Honor.
Okay.
All right. Next, gentlemen.
Your Honor, we also have our protective order as to the documents. We believe that a lot of those, the requests that were included in the subpoena are overbroad, and we were asking for a protective order. That being said, there are some in there that we can work on, and that we would respond to. There are a lot that don't have timeframes on them. One's, for example, is for any lease contracts or agreements between tenants and or Luis Gonzalez, but there's no time frame on it. So, Your Honor, those were included in a protective order because we believe they were broad, and obviously we're not done allowing the proper time frame of 50 days to respond. But if Your Honor would like, we can go ahead and respond to those by answer and objections, and then those can be brought up at a later date in order to keep moving this.
Your Honor, that's a misrepresentation of the court that counsel's making. Number 2 of the areas in which we're asking for, it talks about rental and or lease agreements between Luis and Gonzalez and the tenants and residents at 1316 Acme Lane in 2018, 19, and 20.
Oh, okay.
Correct, Your Honor. And then if you look at number 8 on the next page, it says any lease contracts or agreements between tenants and or Luis Gonzalez. If you look at number 7, I'm sorry, Your Honor.
I'm sorry, is it going to be regarding the same time period, Mr. Hernandez?
Yes, it's the same. It's all
time period.
They all say 2018, 19, and 20.
Okay.
That's what I'm asking for. And so, with regards to what I'm asking for, it's that time period, Judge.
All right, we'll stick to that time period. That'll do it. Okay.
And then, Your Honor, I believe the last thing that, so just for clarification, we are going to, we will respond, and we'll respond unless we want to go point by point on these, that we are also going to have some objections on a number of these other ones, as we believe that they're overbroad and asking for any leases or any pictures or for any tenant. Obviously, we think that is overbroad and can be an invasion of some of our tenants' confidential information. But if Your Honor would like, we can respond to those, and then anything that counsel and I cannot work out, bring before your court.
I would object to that request, given the fact that the requests are pretty specific. We can go one by one if you'd like it. The first one talks about any and all complaints related to ticks, fleas, or insects related to 1316 Acme Lane from 2018 to 2020. And then with regards to the
we don't have a problem with that one, Your Honor.
Okay.
The same scope that we're talking about, judges, we're asking for information that is specifically dealing with ticks, fleas, insects. We're talking about a time frame of 2018, 19, and 20. With regards to photographs, I'm trying to look for that request that I was asking for.
It's on number 7.
Okay. Photographs of the apartment located at 13. I'll withdraw that one, Judge. Number 7. That's fine.
Okay. Number 7 is withdrawn. Very well.
And then when we're talking about number 6 and number 9, it says repair records. I understand inspection and obviously spraying and preventative measures, But are we talking about any and all repair records from 2018 to 2020, even if they don't relate to insects?
No, this again, all I'm talking about is dealing with ticks, fleas, and insects in regards to any repairs that were made for whether pesticide or they're called the, Espadicide,
Okay.
that scope.
All right.
Okay, and then the only other, as long as we have that understanding that they're all limited to that. Number
Okay.
13, a list of all tenant applications, contact information, and lease. And I understand the lease agreements, but Your Honor, tenant applications, I believe, may get into the issue of private and confidential information of people that have applied to be, filled out applications for this property.
And Your Honor, my response to that would be that this has been an ongoing problem based on my understanding of what my client's going to testify. In other words, there's been numerous tenants that have lived there before in which they've had this issue and it's gone ignored. And so although the tenant in the same apartment that I represent is there, the importance and the relevance is to be able to contact these witnesses and to be able to say, was there an issue with this or not? And it's part of the discovery fact finding. It's not to harass them. It's to determine if Mr. Gonzalez says never had a problem, never did it, these ticks are not ours, then there's no way to rebut that other than to seek for that information. That would be the purpose.
Are you saying former tenants and current tenants, or
Yes.
which ones?
Former tenants and current tenants within that same time frame, 2018, 2019, 2020. I don't want to, burden going back years.
And
Okay.
just to make sure, if we're just talking about actual tenants, Your Honor, this just said tenant applications. So technically, people could have filled out an application and then not gone through with it.
No, I think we're
But if
talking about
limiting
actual
it to
tenants.
just the actual tenants.
Actual tenants.
Okay.
Okay. Same time period.
Okay.
That'll do it. That was number 13, right?
Yes, Your Honor.
Okay. Anything else, gentlemen?
Your Honor, the only other thing is I believe we also have set the motion for leave for responsible designation of responsible third party.
Uh-huh.
If Your Honor's ready, I'll go into that.
Okay. Can that be something that can wait after the depots are done, or can it be done now? I mean, I'm trying. I don't want to jump the gun. At the same time, I don't want to disregard it either.
Well, Your Honor, according to the rules, from my understanding, is that we are allowed to designate a responsible third party, and we're actually supposed to do it, within the statute of limitations. So it's something that we didn't want to run or to expire. If after discovery, though, it is evident that the responsible third party has absolutely no liability or potential liability, then the parties can request that be removed under the rules.
Okay.
But I believe as long as we have properly pled allegations in accordance with the pleading requirements that they have alleged liability, then the motion for leave, we would request be granted, Your Honor.
All right, Mr. Hernandez.
Mr. Judge, I think you're correct. I think that it's premature. I mean, we haven't done any depots. And so I think with regards to the motion for leave, at least as we've placed our objection on it, there's no facts to support any of the arguments that are being made with regards to MLMA investments having any sort of culpability or liability or responsibility whatsoever. So, I mean, I would respectfully, if we're hearing it today, that I would respectfully request the court deny the motion for leave to designate MLMA investments as a third party for those reasons that it doesn't comport with the statute.
And Your Honor, if I have may a brief reply. In accordance with section 33.004, if an objection is filed, the motion for leave can be, it can be denied after we have a chance to replead. However, in order for it to be denied, the opposing party, the objecting party, has to show that we did not plead sufficient facts concerning the alleged responsibility. It doesn't say that we have to prove our allegations. And we have actually made these same allegations against MLMA Investments as the plaintiff has made against us. They were the owner and they are the owner of the property. They were the landlord at that time. They knew about the alleged infestation. They made contact regarding the alleged infestation, and they had a duty and an obligation to prevent the alleged infestation, Your Honor. So we believe we have satisfied the pleading requirements because it is not required that we have to prove our case at this time to designate a responsible third party, Your Honor. That's a question for the jury to decide.
Judge, I would just respond by saying that these are facts that are, Mr. Conagy's set of facts, they're not facts that are existence. They're facts that are assumptions that are not anywhere that are placed. I agree he didn't have to prove it, but he can't just state facts just to satisfy the requirement.
Okay. When did this occur? When was the alleged? When did the alleged?
October 7th, Your Honor.
October 7th. What year?
2019.
All right, 2019. So
and Your Honor, if I may, the plaintiff's position and petition states that she believed that the ticks were most likely a result of my client's property. Most likely. That's an allegation. It's not a fact. It's most likely that they came from our client. And we're saying that they had a responsibility, MLMA, to prevent any alleged infestation. And we actually believe, and we'll have testimony, that the alleged infestation actually originated in that property, Your Honor. So we do believe that a designation is proper. It in no way presents liability for MLMA Investments right now. That's not what obviously what a responsible third party does. It is just something to preserve our complaint for the time a jury is involved.
all right. Court will go ahead and grant it.
Thank you.
Okay. Anything else, gentlemen?
No, Your Honor.
All right, then figure out some dates of those depositions and get going so we can hopefully move this thing as soon as possible.
Yes, Your Honor.
Have you all been? You haven't mediated, right?
No, Your Honor.
All right, we'll allow you to do the deposit, and then after that, we might have to mediate or something, but we'll let you know. Okay.
Thank you, Your Honor.
Thank you all so much. You may be excused.
Thank you.